You didn't have to read these to know that you were required to give exculpatory information.
Absolutely not. I've always known that. I've made it clear that I knew that, and that I conceded that even if it were not exculpatory information, they still were entitled to it. However you consider it, they're entitled to it.
And would you agree with Ms. Goodenow that you're required to give that information immediately upon receipt?
I don't know that I would necessarily agree with that, because I don't know that I agree with everything that Ms. Goodenow said, but I clearly agree that they should have gotten that information.
You don't think you're required to give exculpatory information to the defense immediately?
Well, I believe that she said it in that context, but what I try to do is, if you have a complicated report, something like DNA, then it's usually a little easier to give the report than to try to figure out exactly what's said and give that. So I would say that whether it's right or wrong, I wait for the report.
And when you provided discovery on May 18th with your written discovery responses, you were aware of all that information. You were aware of the DNA being out there, correct?
It was not in my mind, but it was something I had been made aware of, yes, sir.
And the discovery was provided in connection with a hearing on May 18th?
Yes, sir.
And that was the hearing at which you said that you provided all information that you had?
Yes, sir.
And putting aside your intent for the moment, that was a false statement of material fact to the court, correct?
Well, it was a false statement in the sense that there was information that I believed that I had given that I had not given, because I did not know that there was something that I knew that wasn't in that report. The problem is that I was not aware that that information was not in the report, and I was not thinking about that information specifically. So the statement that I made was factually incorrect, because I had not given information to them that I had received from Dr. Meehan. But it was not an intentionally false representation.
I asked you to put your intent aside. It is, in fact, a false statement of material fact to the court, correct?
Yes, sir, it is.
All right. And you contend that despite these requests, you didn't read the report before making this false statement of material fact to the court on May 18th.
Well, yes, sir, that's true. I did not read the report before I made that. I just had turned over everything that I had, and I did not read every document to determine precisely what it contained.
And you also provided written discovery responses, which affirmatively represented both to the court and to the defendants that you were not aware of any other exculpatory information which had not been provided, correct?
I believe that's correct, sir.
And you didn't read the report to confirm that the specific results that had been discussed with you on at least one, if not more, meetings were actually contained in that report. That's your contention.
That is correct, sir.
And that subject came up again in discovery requests specifically before the next hearing, correct?
I don't recall specifically, but it may have.
If you'll look at Exhibit 218, which is the first one we went to.
Yes, sir.
That's a request from Mr. Evans, dated May 26th, correct?
Yes, sir. And as far as I was concerned, I had complied with that request before I'd received it.
So you didn't bother to read it?
It's quite possible that I didn't. As I indicated, in terms of requests for discovery, since we're required to give everything anyway, I'm aware of that duty, so I probably did not read this.
All right, and you're aware of your duty under Rule 3.8 that's specifically noted in page 2 of that report?
Yes, sir.
And did you read page 10?
I don't recall what page 10 is, but let me see.
Specifically, on the second bullet point on page 10, the defendants ask for information about the April 10th meeting between you, Detective Hyman, Sergeant Gottlieb, and Brian.
I see that it's there. I don't recall, as I indicated, having specifically read this particular request, because I'd already given everything we had.
And But Mr. Evans' lawyer didn't just serve the request. They actually sent you a letter to put you on specific notice that that issue was going to be addressed at the June 22nd hearing, correct?
If you say so, I don't recall specifically the letter. Is that in here too?
Yes, it is.
Could you give me a number reference?
Take a look at Exhibit 220, please.
Yes, sir.
And that's a letter to you dated June 19th, which is before the June 22nd hearing, correct?
Yes, sir.
And on page 2, paragraph 8,
yes, sir.
they list the same request, correct?
Yes, sir. I actually do recall. I believe this is probably what we went over when we were making our specific response in the courtroom. I think it was probably this letter was the one that we used as a model. Yes, sir.
That's right. And they were putting you on notice on June 19th that at that next hearing, they wanted to discuss that specific issue. They wanted to know what you had been told on April 10th, 2006 in your meeting with Dr. Meehan.
It does say that, yes, sir.
And that issue, in fact, came up at the June 26th hearing, didn't it?
Yes, sir, it did.
And in that hearing, you represented that there was no discussions at all at the April 10th meeting with Dr. Meehan that weren't attorney work product.
Do you have a reference for that?
Exhibit 222, page 20.
I don't know if this is a particular transcript or not, but there was one that I recall in particular where they were asking about a meeting on April the 10th, and it was clear that I was answering the meeting about May the 12th. Yes, this one.
Well, let me ask you if this is what the transcript says, and then I'll ask you a question. Mr. Cheshire, as far as 8 and 9, 8 is the 8 that we just looked at in that letter, there are similar arguments I would like to make to the court. I understand that Mr. Nifong said about 8, and that is the report of the meeting on April 10th among Mr. Nifong, Investigator Hyman, Sergeant Gottlieb, and Brian Meehan. And as I understand what he says, there was no discussion at all that wasn't attorney work product at that meeting. And your response is, that's pretty much correct, Your Honor. We received the reports which he has received, and we talked about how we would likely use that, and that's what we did. Correct? That was your response.
That was my response, and it seems the meeting that we received the reports was the May 12th meeting. As I indicated, I did not recall actually having had an April 10th meeting. And so, although I didn't make it clear, I seem to have assumed here that I thought he was referring to the May meeting rather than the April meeting, because I said we received the reports, which he has received, and that clearly did not happen until the May 12th meeting. So I think that I may have misunderstood what was being discussed here, and I gave a response about the May 12th meeting.